I'm Alan Sykes today with Scott Sykes of Sykes and Company PA, and also with Jesse Dresser of Frier Levitt. And welcome again today to the Master the Margin Pharmacy Influence series that we've established this year, where we're bringing in a number of key vendors as they would be in this industry. Obviously, Frier Levitt is a key healthcare legal specialty firm that is dealing in this industry. Today we have obviously an extraordinarily interesting topic that I'm sure everybody will be interested in. And again, it's our pleasure for everyone to be on the call today. This will be recorded and will be on our website, and also for those that are listening to this after the fact through recording, if you registered, the recording will be sent out. But Scotty, you want to make a comment and then pass it on to Jesse in just a second?
Sure. So, the Master Margin series here, it's actually the second year we've been doing this, so we've been getting some good feedback on that, but we're definitely happy to have Jesse on today to talk about reimbursement trends and tools for the independent pharmacy space. Obviously, Jesse and his group there specialize in the independent pharmacy area, so we have a lot of shared mutual clients, etc. But we're certainly glad to have him on today. And let's get through these slides here. There's some information on Jesse there, email and phone. But I want to start off, and again, thank you, Jesse, for getting on with us today. But I just saw the breaking news on the Supreme Court Rutledge case, and that it was an 8-0 decision in favor of Arkansas and Rutledge there. So just want to get your opinion on, or your feedback on what you think that means and what it looks like going forward.
Thanks, Scotty. Thanks, Alan. So this was a great victory for the independent pharmacy community. It was a matter that we've been following for quite some time, several years at this point, and frankly, a matter that has had ripple effects along the way in not just Arkansas, but in several other states that had looked to pass similar legislation that was shot down on the same legal theories and justifications as what was originally at place in the Rutledge decision. So, going back, this dealt with a very particular law in Arkansas, Act 900, that sought to regulate MAC pricing, and PCMA, the Pharmaceutical Care Management Association, filed, as they almost always do, invariably and instantaneously, a lawsuit challenging the law to try to stop it from going into effect. And after a couple rounds at the district court level and then the 8th Circuit Court of Appeals, it worked its way up to the Supreme Court. What was very interesting about this case at the Supreme Court level was you had not only the state of Arkansas, Rutledge, pushing this all the way up to the Supreme Court to challenge and to push for the enforceability of this law. But what was very interesting, when they made the application for certiorari, which is the agreement to actually hear the case at the Supreme Court level, the United States government actually stepped in and wrote in favor of the case to be taken up at the Supreme Court level, because they expressed views that they felt that this law should not, ERISA should not preempt these types of state laws. And so a lot rode on this case. There was a lot of debate in the industry. There were a couple dozen amicus briefs submitted. Our firm actually put forth an amicus brief on behalf of a trade group representing independent providers, as well as a couple individual providers themselves. There were amicus briefs submitted, many on the side of providers in favor of the law, a handful on the side of insurance companies and plans that were in favor of striking down the law, essentially upholding the 8th Circuit's decision. So a lot went into this. And what's really interesting is the Supreme Court's ultimate opinion in this case was a lot broader than I think people thought it might be. When I first saw the news that they had overturned the 8th Circuit's decision, I started with a little trepidation, a little nervousness that yes, it was great that they'd overturned this law, but I had some concern that their opinion would be narrowly construed and tailored to the exact language of this particular law, this Act 900. And you know, to our surprise and excitement, the opinion is actually a lot broader and more generalized than maybe I initially feared. And I think what's going to happen is it's going to provide great ammunition to push back and really pop the bubble on and pop the balloon on PCMA's efforts to immediately lodge a challenge on a lot of these state laws. So what I think it's going to mean in the immediate terms, there are several other state laws that were challenged by PCMA that had decisions that were rendered in the wake of the Eighth Circuit decision, where they essentially struck down the law. There was a law in North Dakota, a law in Iowa, a couple laws in some other states that were being challenged under the auspices of the Rutledge decision, and the courts had ruled in the same way that they ruled in the Eighth Circuit before the Supreme Court ruled on it. So they'd actually been struck down. So I think what's going to happen immediately is there's going to be new challenge to those decisions, and I think we'll find many of them get reinstated because of this decision. So I mean that's great immediate relief. The other thing that I think it does a little bit more long term is it really puts the spotlight on states to recognize that their hands are not tied in terms of regulating PBM conduct per se, that they do have the legal right and legal ability to regulate certain activity and to pass laws that are going to withstand scrutiny as being alleged to be preempted by ERISA. So what that means, I think, for the independent provider community, independent pharmacy community, is they have a renewed opportunity to go to their state legislators and educate them and provide guidance on the abuses that are happening in the industry, the imbalances that are happening in the industry, and the importance of passing effective legislation and the opportunity to pass effective legislation that's created by this. It's, you know, on the whole, a very exciting day for independents. A lot rode on this. If the court had ruled in favor of PCMA, in theory, not only could these laws like the MAC laws and some others be challenged by PCMA, but potentially the scope of ERISA preemption might not even stop there, and it might not be long for PCMA to start to go after other laws like the anti-willing provider law or some other laws that provide protection to independent pharmacies. So all in all, very exciting news today. I know it's being discussed widely in the industry, and I'm sure you guys have seen plenty of inquiries about it yourselves.
Absolutely, absolutely, and clearly it's going to have far-reaching impact in the weeks and months ahead, and it'll be very interesting to follow this as it progresses here. But I was a little bit shocked to see it was an 8-0 decision, and quite pleased to see that. So, be that as it may, we're happy that something finally positive is hit the industry here as a whole.
And the industry can start to go on offense here with these changes.
Correct.
So, Jesse, with that, let's roll into the webinar of topic today, which is the PBM and reimbursement and whatnot. So I'm just going to let you take it from here.
Great, thanks again. So as mentioned, my name is Jesse Dress. I'm a partner with the law firm Frier Levitt. We're a boutique healthcare life sciences law firm, and as you can see by my actual 4 layers of clothes, we're based in the Northeast, so it's a little chilly up here. But we cater to the pharmacy industry in particular. There's a big focus in our practice group on independent pharmacy providers, retail pharmacies, compounding pharmacies, specialty pharmacies, even dispensing physician practices that bill for pharmacy services. So I head up the pharmacy practice group within the firm, and a big area of our focus is on the relationship between the pharmacies and the other stakeholders in the drug supply chain, whether that be the wholesalers, whether that be the PBMs, insurance companies, or other folks like technology companies, hub service providers, and the like within the overall drug supply chain. One of the issues, one of the topics that has become almost the singular greatest topic of discussion, and one that obviously was impacted by the Rutledge decision and others that we've talked about, is this concept of pharmacy reimbursement, how pharmacies are being paid. Historically, there had been a lot of discussion about whether pharmacies should be a network, what the abilities were of PBMs to exclude them from the network. The discussion has shifted a little bit to a discussion more about how pharmacies are paid. With the increase of any willing provider laws, particularly at the Medicare Part D level, there's a little bit less debate over whether PBMs have the right to exclude a pharmacy. They kind of have said, okay, fine, we're not gonna engage in that fight over necessarily excluding the pharmacy altogether, but instead we're gonna do different kinds of tools and different types of strategies around reimbursement that make it very difficult, if not impossible, for the pharmacy to profitably stay in network within these networks. We're gonna make it so that it's very difficult for the pharmacy to be profitable and to have positive reimbursement, and very unattractive for independent, non-integrated pharmacies to be members within our network. So that's why a big topic for today's discussion is the concept of PBM reimbursement trends, what the impacts are on pharmacies, and what some of the tools are that they can make use of. So I always find it helpful to really understand how pharmacies are paid for the claims that they dispense to PBM's beneficiaries. So at the outset, I have here kind of on the left part of the slide a gray box that really highlights the pricing methodology, the reimbursement methodology that's used by PBMs when they pay. And it's typically an agreement to reimburse at the lesser of the contracted AWP discount plus a dispensing fee, the MAC price plus a dispensing fee, the usual and customary price, or as otherwise set forth in an applicable rate schedule. And that beauty contest, so to speak, is typically set forth in one or more contract documents that the PBM puts out, or that get put out through the PSAO on behalf of the PBM. To understand, though, how you're going to get paid, it also requires an understanding of what each of those terms are, how each of those are regulated, how they're defined, and what kind of the impact is on the pharmacy. It also depends on how the claim is submitted. So, I have on here a couple NCPDP fields that are important for pharmacy operators to kind of be aware of and track. The first is basis of cost determination. That's NCPDP field 423-DN. And essentially what that is telling, when you submit a claim, you as the pharmacy submit a claim, and you're billing the PBM for a particular product using an NDC number and submitting a price, that field indicates how you're submitting that price, whether the price that you're submitting is AWP, whether the price that you're submitting is your usual and customary, whether the price that you're submitting is a 340B price, or something else. That field is articulating how you're submitting the price. And the reason I say that's important is it may sometimes dictate how you're reimbursed. If you have a lower usual and customary price, but you're not reporting it, you're only reporting the AWP, it might mean that you're going to get paid based off that AWP, even though your usual and customary price might be lower, and that can be an issue.
And we have seen that. We have seen pharmacies that are submitting claims maybe below what the maximum price would be, and the PBM's paying them that lesser price, and we're seeing that impact your margin. So if you're a pharmacy out there with some severe margin issues, this is an area I would be looking at if you have not looked at this area.
100%. If you are reporting, for example, as Scott mentioned, if you're reporting a usual and customary that is artificially low and not the actual price that you're charging cash paying patients, you're essentially leaving money on the table that you'd otherwise have the legal right to go after. Now, obviously, if you're charging cash paying patients as a usual and customary price less, you have to pass that along generally under the contracts. But if you are because of inadvertent error, or you haven't updated your systems and you're still including essentially a fictitious or dummy usual and customary price, you could be artificially losing money. Another concept that's important to take note of is pharmacy service type. This is NCPDB field 147-U7, and this clarifies what type of pharmacy claim is being submitted, whether it is a retail community pharmacy type claim, whether it is a specialty pharmacy type claim, whether it is a long-term care pharmacy type claim, whether it's a home infusion type claim. That how you submit that is going to oftentimes dictate what reimbursement rates apply. A PBM might have a different reimbursement rate for long-term care pharmacies than it does for retail pharmacies. It might have a different reimbursement rate, including level of effort or including additional dispensing fees if you're a home infusion pharmacy. Or, alternatively, it might mean that you get a rejection if you bill using a long-term care pharmacy code, but you get a paid claim if you bill using a retail pharmacy code. The important thing is making sure that whatever code you're putting is accurate. And frankly, there are some times where it's not crystal clear, and there could theoretically be more than one reasonable code that could be used. And it's important that if you're running into those questions, you seek counsel and seek advice on making sure that you're doing it right. The other NCPDB field that I have on here is 420-DK. That's a submission clarification code. We see that come up a number of times, whether it is in the compounding space and you're trying to get reimbursed just for the ingredients that are covered and you don't mind not getting paid on the ingredients that are not covered, you might use a submission clarification code. But where we oftentimes see it more and more commonly is in the 340B space. Many PBM contracts are increasingly requiring pharmacies, when they are dispensing a 340B claim, to use a submission clarification code of 20 every time that they process a claim for a 340B eligible prescription. In turn, what that'll do is it'll provide 340B specific reimbursement rates that oftentimes we've seen are substantially lower than what you might otherwise get if you're not billing a 340B claim. And then the other important thing for folks to keep in mind is the data that comes back. So all these things are things that get pushed out, but every time there's a reimbursed claim, you're getting a whole set of data that's coming back. And so when you look and see how you're getting paid, it's important to take note of the basis of reimbursement. How is the PBM paying you? Are they paying you based on your usual customer? Are they paying you based on MAC? Are they paying you based on your average wholesale price discount? Important to keep in mind, especially when you start to, and this is something a lot of our clients have done, they'll take a look at what their contracts say in terms of reimbursement, and they'll take a look at where certain plans should sit within different contracts and what types of networks they should be in. And they'll say, wait a second, I'm supposed to be getting a certain rate on all patients in this particular benefit, this particular group's network, yet I'm not getting the right dispensing fee, or I'm not getting the right AWP discount. And looking at the claims data, and in particular how you're getting paid, is important, because it's going to help you be able to make that case to the payer if necessary, to say, hey, listen, I'm not getting paid properly. The agreement that we have doesn't mention anything about MAC pricing, yet you're macking these products. That's no good. Or my contract says I'm supposed to get AWP minus 18%, but you're paying me AWP minus 20%. That's not what my contract says. And we've been successful in working with folks to go back to the PBM and correct those types of underpayments. But focusing on how they're calculating your reimbursement using that field is important. So looking over here at this other diagram here of these different types of pricing methodologies, a lot of these are common knowledge to the pharmacy industry. Average wholesale price, AWP, is I always liken it to manufacturer suggested retail price. It's not necessarily tied to what gets paid, but it's a benchmark price that gets set by the manufacturers and is typically used as a benchmark price when the PBMs are contracted with pharmacies, and they'll say, we'll pay you AWP discount, AWP minus 15%, something like that. You also have wholesale acquisition cost. This too is a reported price. It's tends to be a little bit closer to actual acquisition costs. But again, it's a benchmark price, and there could be variances between what a pharmacy buys it for and what the reported WAC price is. And typically you see reimbursements contracts that call for WAC price reimbursements to be, WAC plus or minus, a couple of percentages. It's not, huge AWP discounts like we might see of, AWP minus 25%, AWP minus, 80% even for certain generic products. Wholesale acquisition prices are usually, plus or minus 1 to 2%. Maximum allowable cost, MAC. This is another concept. This was at heart of Act 900 from Arkansas. It is typically reserved for instances where there are multi-source generics. There are more, essentially more than one version of a product on the marketplace, and the PBM is going to look and they're going to say, okay, there's 3 products in the marketplace. We're not going to pay more than the cheapest one. And if you want to go and dispense the more expensive ones, be my guest, but we're not going to pay you anything more than what we pay for the cheaper one. The dangerous part there is a lot of times PBMs base their MAC prices off of products that aren't available in the marketplace or shouldn't be duly put as a MAC product. So it's important, when you're looking at how you're being reimbursed, and if you're being reimbursed at MAC, to make sure that they're otherwise comporting with the rules around MAC pricing. I also have on here average sales price, ASP. This is another benchmark price. It's because it's a construct of Medicare Part B as in boy, there's typically a bit more regulatory backing behind it to make sure that it's accurately reported. It's typically the basis that we see folks get reimbursed when they bill a drug as a medical benefit. Instead of billing to the PBM, you're billing to the health insurer. And we see it a little bit more in the home infusion space, although there are certain products that have been able to be billed as medical benefits or otherwise billed to Medicare Part B as in boy.
I got a question, Jesse.
Sure.
If you're a pharmacy owner out there and wondering, how could you begin to start to analyze how you're being paid, kind of take a deeper dive? What's a practical approach a pharmacy owner out there could do to kind of start to get their feet wet here into this area to see what's going on and to maybe improve how they're billing?
Yeah, so the simplest thing that pharmacy owners should do, and too often I find that they don't, is collect and review their contracts. Understand how you're contracted with the payers, understand how they break up their networks, and above all else, track and receive and hold on to all the communications you get from the payers, all the bulletins, all the updates, all the network schedules. Get it, receive it, begin to unpack it. If you're working with a PSAO, try to have a regular communication with them, because the notices aren't going to come to you directly. They're going to go to the PSAO, and it's going to be your responsibility for making sure that you're getting them from the PSAO. And far too often we find that people just don't have that critical information, because you're really not going to be able to determine whether you're being paid right if you don't even know how you're supposed to be paid to begin with. So that's step one. From there, it depends on operators' level of sophistication. If you have a basic agreement with your pharmacy software system, I would start there. I would ask them what their capabilities are of generating some of this information. There are some consultants and some folks out there that can do some amount of this, and so it might be worthwhile to speak to them to help get that level of analysis. But beyond the ultimate, where you're ultimately getting is data, right? If you get the raw data from all the claims submissions that go to the payers and all the claims responses that you get from them, that's going to be where you're going to dive into it, and you're going to start to find the variances, where you're going to say, okay, I'm matching up this bin, this PCN, this group number, this network contract ID, and the rate I should be getting is AWP minus 15%. The rate I'm getting on average is AWP minus 19%. That's a problem. I'm going to present this to the PBM, or if it's a Medicaid program, I'm going to present it to the Medicaid director. That's kind of where I begin with it.
Here's a question that just really popped in my mind. Are there services out there that actually will audit these adjudicated claims back to what you just said for some type of fee in order to make sure that what you just said takes place?
Yeah, so there are certain vendors that indicate that they can do that. You know, I've seen varying degrees of success with it in some of the folks that have done it. You know, it somewhat depends on data in, data out. You know, if you have the right information coming in, the more accurate information coming in, the more accurate your information coming out will be. The problem has been that the PBMs make this output data extraordinarily difficult to get. You know, it's against their interest to make it easy to know how you should be paid under particular networks, and so it really requires a lot of work to make sure you're getting that accurate information in. And the instances where I've seen it be successful is where they have a greater ability to get that information in. Now certainly some much larger organizations, you know, maybe larger chains or some supermarket chains or large, very large independent pharmacies might have a team of people that are able to track this. But even some smaller independents that I've worked with that are just really dedicated to getting the numbers and getting the data have been able to make dents on it. Another concept that I want to mention quickly: 340B pricing. 340B has exploded in terms of its proliferation. One of the issues that we've seen, however, certain payers have said, okay, if it's going to be a 340B claim, we're not going to pay you the normal AWP discount. We're going to pay you something else. So normally we'll pay you AWP minus 15% on a brand, but if it's a 340B claim, we want to capture that. We're going to pay you AWP minus 33%. And they're going to want the pharmacy to go and submit the correct 340B submission clarification code to identify it as a 340B claim, and then in turn pay them a whole lot less. So that's been something that we've seen. We've also seen issues too about reconciliation issues between the 340B contract pharmacy and the third-party administrator who acts kind of as a middleman between the 340B contract pharmacy and the 340B covered entity. Particularly when we start to talk about these other couple things on here: direct and indirect remuneration fees, brand effective rate, and generic effective rate. You know, if you submit a claim on day one and you get paid $100, and the 340B third-party administrator brings, you know, all but the $5 dispensing fee out and passes it on to the covered entity, that's all well and good. But if there's a 5% DIR fee that gets applied 12 months later, that's coming out of your money. That's not coming out of the third party administrator's money or the covered entity's money. Now that $5 dispensing fee that you just got reduced down to zero. So you know, those are issues that we've seen come up as well when it comes to 340B relationships. Direct DIR fees, BER and GER. I'll talk about those in a couple other slides, but they are proliferating in terms of, you know, how common they are in different payers' agreements. But the interesting thing is there are some growing sets of laws at state level looking to try to drill down on some of these, as well as some very interesting developments from a litigation perspective on some of these as well. So we can hop to the next slide.
All right.
So direct and indirect remuneration. This has become a big issue for pharmacies, both regular retail, independent pharmacies, as well as specialty pharmacies. DIR stands for direct and indirect remuneration. It was originally coined by CMS to address the price reductions that were coming after the fact from manufacturers in the form of rebates to reduce the net cost of the drugs that weren't otherwise captured at the point of sale. PBMs have essentially hijacked the term DIR to allow them to charge plans and in turn patients a higher point of sale price. You know, if you're a patient, you're paying a 20% co-insurance. They would much rather have you pay that at a price that is higher at the point of sale, only to be reduced after the fact by net by DIR on the back end, because they shift their liabilities. So, you know, for example, if you have a patient that's paying a 20% co-insurance on a $100 medication, they are going to be paying $20. Now, if a $5 DIR fee is taken off the back end, instead of them paying 20% of the cost of the drug, they're actually paying something like 21, 22% of the cost of the drug, the net cost of the drug. And the plan is only paying, instead of paying 80, they're paying, 79, 78%. So, on an individual level, might not seem like a ton, but spread out over every single claim across an entire network of business, it becomes very, very lucrative for some of these big PBMs. And so that's been one of the big areas of focus for PBMs over the last couple of years, is really expanding these types of programs. We can go to the next slide. So these are some examples of how direct and indirect remuneration, DIR fees, are not only calculated, but also how they are assessed. So in terms of performance criteria, there are a couple of different ways that they measure performance. One of the ways is this concept called Net Promoter Score, NPS. This is a framework where essentially they send out surveys to your patients, not even all your patients, just a subset of your patients. And they ask, how likely are you to recommend this particular pharmacy to another person? And these kinds of Net Promoter Scores are common in a lot of different industries, but they don't really necessarily make sense, particularly in the pharmacy space. If you have someone that rates you 8 or 9 or 10 out of 10, that's considered a promoter, and you get a point for that. For anyone that rates you between 6 and 8, they are neutral. And then for anyone that's 5 or below, they're a detractor, and essentially they take away from your score. And so that's essentially how they calculate it. But the problem is, a lot of the questions are geared to how was your experience with them, how likely are you to recommend them. So let's say, for example, you are a oncology, you're focusing in the oncology space, and you're treating someone who's got terminal lung cancer, and you're basically just trying to keep them alive for another couple of weeks before they are slowly dying of a really uncomfortable and terrible death. And now they're being asked, how likely are you to recommend this pharmacy to another colleague? They're not really going to be in the right mindset to, regardless of how great of service you actually perform, they're not going to be in the right mindset to give you any kind of score. So it's really skewed against a lot of the folks in this industry, particularly those that are dealing with disease states that maybe aren't the happiest to deal with. Another concept that gets used is generic dispensing ratio. This is the number of generics that are dispensed relative to your overall drug mix. It also can really impact folks that are focused on areas that tend to have a bit more brands involved, for example, oncology or some other segments that tend to have fewer generic choices, and it's really just a matter of dispensing brands. It can skew against them and unfairly score them poorly. Also, the concept of formulary compliance. This is how often you're dispensing a drug that is listed on the payer's formulary. Again, depending on your disease state that you're focusing on, or your particular patient community, it might not be something that you really have much control over. The final performance criteria is adherence. This is typically either a percentage of days covered or member possession ratio. They both essentially are measuring the total amount of days in a given period versus the total amount of drugs that are in a patient's hand. They're calculated slightly differently. And again, one of the problems that is faced here is it might not always make sense to dispense a medication to a patient. If they're having an adverse reaction, or if the doctor has directed that they just kind of test the waters a little bit and they only want it partially filled. Those are things that are actually in the best interest not only of the patient, but also saving the plan money, but could actually penalize you from a performance standpoint. Now, in terms of the therapies measured, they do measure a number of these types of performances across a couple of different therapies: diabetes, hypertension, statins. Those are probably the 3 most common. We see them a lot on the retail side. Some of these others, like hepatitis C, autoimmune and RA, MS, AIDS, HIV, oncology, those are things that we tend to see a little bit more on the specialty side. And then in terms of assessment, we see it come in a couple of different formats. Sometimes what we've seen is actual increased point of sale reimbursement, but then a deduction from remittance at the time that you actually get paid. So, you might get paid at the point of, you might get adjudicated at the point of sale at AWP minus 11%. Well, so, let's say AWP is $100, you might get adjudicated for $89 at the point of sale, but when you actually get paid, they only pay you $80, and you now have the ability to earn back that 9%, that $9. That would be an instance where you never actually got paid on it, and you just have earn back potential. Another concept we've seen is full remittance, but later in time clawbacks over trimesters. So, in this instance, for that first claim, you might get reimbursed you might get adjudicated at AWP minus 15%. So you're getting $85. You get paid $85, but then months later they adjudicate they assess the DIR fee, and you get $5 clawed back from you in future remittance cycles. The one, in the first model, you never actually got paid, so you don't have to really worry about it from an accounting perspective. The second one, you have to be careful, and you have to accrue, because if you don't accrue properly, you might be taking into income monies that you're never actually going to be able to keep. Particularly if you're having a DIR that's at minimum 3%, you're guaranteed to have 3% of what you just got paid taken back. As I have here, you have DIR fees that range 1.5% to 16%. So there's a pretty big range of how big they are. Most, I'd say, are probably in a 3 to 6% range.
Yeah, that's what we're seeing in the 3 to 4, 3 to 5% range, really depending on what the star ratings are on average.
And we have seen them pretty stable year over year from 19 to this year. We haven't seen a huge jump increase like we have in prior years. But a lot of things we hear is when we're on the road or talking to pharmacies is that, I don't track DIR fees in my accounting. I'm not sure. It all ends up being the net number, net income, no difference, which is true. But if you're tracking it, where you stand here in this 3 to 6% range, or where your DIR fees are as a percent of revenue. Then you understand where you are compared to the benchmark, compared to the averages, and then hey, maybe there's something I'm missing or not doing right. So it just opens up another layer of analysis you can do in your pharmacy. Now, Jesse, what from this slide here, what can pharmacy owners do to control this, to control those DIR fees to some extent? Because we hear a lot of times, hey, DIR fees are what they are. I can't do much about it. I can't do anything about it. There is some level of control pharmacies have over minimizing this impact. Is there not?
Yeah. So, well, it depends. So if you are a specialty pharmacy, let's say you're focusing on dermatology, and you have none or virtually no patients that are diabetic or hypertensive or require statins, you're not going to have any ability to influence those categories. If you're being measured on those categories, you just don't have any patients, and you're not going to be able to measure it. You're not going to register. And what we've seen more often than not is those folks are penalized essentially for not having any patients in those categories. It might not mean that they are directly penalized, but instead what happens is they're given network averages that oftentimes happen to reflect scores that are worse than what they would otherwise perform in the categories that they're being measured. However, if you do have claims that are in those spaces, there are steps that you can take to improve your scores. We've had a number of clients that really look at what is being asked of them for these performance criteria and dedicate teams to do it. If you're big enough, a shift of 50 basis points in terms of your overall score could be a couple $100,000 to your bottom line. So we've had folks that have put teams together to increase scores, and sadly, what we've actually seen in some instances is our own tracking of our scores, our pharmacy's own tracking of our scores, reflects something different than the score that's actually being given to them by the PBMs. And in those instances, we've actually pushed back in some of those instances, said, listen, we were very attentive to making sure that our scores improved. You score us improperly, go back and fix it. And in some instances have had very simple success, even with just a written letter saying, fix these scores, you did it wrong. And it's resulted in some instances 6 figures, 7 figures of altered DIR. But certainly in terms of addressing the quality and the performance criteria, it definitely is something that pharmacies have most times have some ability to impact, particularly if you're doing traditional retail work. There are some companies that exist out there that have developed tools to help identify instances where you can do MTM, where you can do interventions, where you can do some of these things, or measure real time your formulary compliance or your generic dispensing ratio, for example. But on some of these, like Net Promoter Score, there's not a whole lot you can do to engineer that. Other than doing as best of a job that you can and coaching your patients and making sure that you're not ending the touch with them until they're completely satisfied. There's not a whole lot you can do there. So and that's what kind of dovetails into the next slide about these programs as a whole and their overall legality is your ability to actually influence them. So big question again, DIR fees is the tip of everyone's tongue. It's a huge issue for a lot of folks, and so people are often asking what's being done, what can be done about them. So in terms of litigation, in terms of legislation, there have been, since DIR fees really proliferated in 2016, there have been half a dozen bills that have been introduced, all without any success at regulating or reining in DIR fees, at least at a federal level. There are many bills that have passed at a state level that essentially make DIR fees illegal. But again, as we talked about at the beginning of this, with federalism and ERISA and Medicare, Medicaid, those state laws don't impact at all Medicare Part D. Medicare Part D is regulated at the federal level. So while it's great that those states have those types of laws, and they actually can be used, as I'll get into in a minute, in context with GER and BER, they don't have an impact on most DIR, which is in the Medicare Part D space. What I can say, though, is there have been multiple rounds of rulemaking efforts aimed at addressing DIR, and in particular, removing protection for DIR, primarily for rebate-related DIR, but also to some degree for pharmacy-related DIR, removing that rebate protection, removing that safe harbor protection, unless those amounts are passed through to the patient at the point of sale. Meaning, if you're going to reduce the overall net cost of the drug from $100 to $80, that patient has to be given the benefit of that reduction. It can't go to the plan. A rule incorporating some of this was recently kind of pushed through by the Trump administration a couple of weeks ago. It's really unclear how it will stand up. What's interesting is the rule was done at the same time that they introduced or finalized another concept called most favored nations that applies a little bit more on the Part B side of drug reimbursement. But there's already been talk about challenge by the pharmaceutical industry, challenge by some provider organizations, and obviously, with what happens in January, it's really not going to be clear what's going to happen under the next administration. So we'll see there, but that's unfortunately, legislation hasn't really proved to be the big solution for this. What's interesting, though, is there is a DIR fee annual reporting requirement that requires PBMs and actually plan sponsors to report any DIR, including pharmacy-related DIR. there have been efforts to increase the amount of data that has to be given by plan sponsors related to that DIR. And I think that the more that can be given, the better understanding CMS will have of this issue. In any event, we've found that the more people that get involved, whether it's communicating with legislators, whether it's communicating with CMS, whether it's taking action directly against the PBMs themselves, has had some serious material impact. And what that really culminates in, and I have it on here too, is this concept of arbitrations. So most PBM contracts call for arbitration before the AAA. There are a couple that allow for litigation in federal court. But what we have found is many PBMs have dispute resolution provisions that allow you to raise grievances about the DIR, whether it's that it was calculated inaccurately. You're not necessarily challenging DIR as a construct, but you're saying you even under your own rules, you got the numbers wrong. We've had cases like that, but we've also had cases where we've addressed the concept of DIR more broadly. Are the performance metrics fair if I don't have any claims that fit into any of these categories? Is the DIR fee structure fair in that 99% of the time it results in me losing money on the prescription? Medicare Part D has a rule in the Medicare Part D manual that says terms and conditions must be reasonable and relevant, and a reimbursement framework that pays you below your acquisition cost is not a reasonable term and condition. That's part of the anti-willing provider law. We have leveraged that in the past as well to challenge DIR fee programs. And while arbitrations are generally good because they're confidential, one of the challenges we run into is when we do have good results, when we do have positive developments, we can't always share it in the way that we would want to share it because they are limited in some of these confidential proceedings. Now, hopefully as more folks get involved and more things happen, it'll be a little bit easier to kind of make that a little bit more well known. But at this point, what I can say is that we have brought cases, whether it's litigation or arbitration, against multiple different PBMs and have had success against multiple different PBMs on this issue. So I encourage anyone that has had any kind of substantial DIR fees taken out from them by any of the major PBMs to reach out, and we can talk through different types of strategies that are available. The other thing too is we've been able to do a lot of these on alternative fee arrangement bases where we're not charging a straight hourly fee. It might be flat fees with certain success fee components. It's not something that we're just asking for a blank check to go and do a bunch of things on your hourly dime. Instead, we want to deliver value and tie our fees to whatever value we're able to deliver. So next concept is generic effective rate and brand effective rate. Again, these are technically a form of DIR. Essentially what they do is they set an average aggregate network discount on generics or brand drugs across all pharmacies in a particular network. They're typically measured on a network level and unfortunately been very opaque in their implementation and execution. We actually saw a couple where the PBM basically forced PSAOs to sign a GER agreement that was signed, in the middle of the year, but made retroactive to the beginning of the year. So you had pharmacies being paid, from January to June on rates that are then changed after the fact, and now the PBM has this ability to true it up and to reconcile, and so they're facing these massive GER or BER reconciliation recoupments at the end of the year. And something that they had no knowledge of at the time they were actually dispensing the claims. Another concept that's started to emerge is dispensing fee effective rate, the DFER, where over a course of an entire network, the dispensing fee might average out to 50 cents, but that doesn't mean on every single claim they have to pay you 50 cents. That's another form of kind of varying fees that we've seen evolve over time. So to understand GER, It's helpful to think of it in the context of MAC pricing. So, MAC pricing, you have 5 different drugs. The PBM might say, okay, well, there are 5 different drugs in the marketplace. We're going to set a MAC price of $19, and any drug that's over that, you can dispense it, but you're going to wind up losing money. And instead, you want to be pushed to dispense some of those drugs that are below that MAC price. Now, if, however, some of those drugs that you're dispensing, and I apologize for the formatting of the slide, if some of the drugs that you're dispensing are, even though they might technically be below the MAC price, their AWP discount doesn't happen to be as steep as it could otherwise be. For example, if you're dispensing too many of drugs 2 and 3, you will find that you're actually, and let's say the generic effective rate is AWP minus 87, you will actually find that you're running below the generic effective rate, and they might want to in turn true it up and say, okay, well, your average AWP was actually closer to 84, 86%. When you dispense too many of those products, our GER is 87%. We're going to have to take back that 1%. So another concept I want to talk about is this concept of medical benefit versus pharmacy benefit. We've been seeing more and more products that are kind of being shifted from one side to the other. Medical benefit, these are typically processed on the medical side, typically more open networks, less likely to be rerouted to PBM-owned pharmacies, and oftentimes will include reimbursement for ancillary services. The pharmacy benefit obviously is processed by the PBM side, more likely to have restrictive networks, and there's more incentive for the PBM to direct business to their wholly owned pharmacies, and also less likely to see reimbursement for some ancillary services. Now, what we're seeing is a greater trend of PBMs trying to merge that medical benefit, if you want to go to the next slide, trying to merge that medical benefit into the pharmacy benefit and instead require products be white bagged instead of being handled by a provider or being handled in a clinic, to be white bagged by the PBM owned specialty pharmacy. So a lot of drugs that were historically bought and billed or infused are now being sourced directly by the PBM owned pharmacy. So with that, I think what we'll do is we'll end here. We have about, it looks like we have about 5 minutes left, and I do want to open it up a little bit for questions and additional dialogue, since we only got another.
Yeah, Jess, we got a number of questions here, and real quickly, for those that are registered, this is being recorded and will be sent out to you if you were registered. Also, it'll be on our website, sites-cpa.com, within a day or so. But let me just quickly go through some of these questions. This gentleman says, ask my PSAO for help on local independent PBM contracting. They would not help because it was not on their level. I would have thought that they would at least give me an opinion on what to do, to sign it or not sign it. A lot of help they were. Really, they don't have time for us individually. Anyone better? What PSA? What's the better PSAO to use in that arrangement?
Yeah. So unfortunately, that has become a growing concern about folks using PSAOs. PSAOs are they have a big business relationship with the PBMs, and they have a lot of different constituents, a lot of different business arms, and that's just the reality of the situation. So a lot of times, particularly for smaller independent pharmacies, and even more so those that maybe don't meet the traditional definition of a retail pharmacy, maybe do too much mailing or too much compounding or too much specialty, they're getting pressure by the PBMs to limit their network to just pure retail pharmacies. What I've oftentimes found is after a pharmacy has reached out to their PSAO and gotten a response, a lot of times we're able to help them, either help them ask the right questions or direct them to the right people within the organizations. Unfortunately, there have been times with certain PSAOs that we've had to threaten litigation to get copies of the contracts that they, as the attorney in fact for the independent pharmacy, have entered into on our behalf. But that's generally what we've done in some of those instances. The broader question of PSAO versus not PSAO, I think that's really a pharmacy specific question. I think it depends on your business model, depends on your level of sophistication and bandwidth. Really, if you're already stretched to the max, you really don't have the bandwidth to go and negotiate and manage every single contract with every single payer. It might make more sense to go with a PSAO. But if you have the bandwidth and you have the opportunity, it can free you up quite a bit.
Let's kind of get through the RX assessment real quick, then we'll take a couple more questions. We'll let everybody go.
Yep. We have an RX assessment service. So if you're a pharmacy out there wondering, whether you're capturing DR fees correctly in the accounting and how you're handling that, or any other numerous issues you may have or have concerns about, we do a assessment where we take the accounting file, your tax returns, overview that internally, get you on a video call, and then we walk through the balance sheet, the P&L, your tax, and give you a full third-party overview of what we see, good, bad, and indifferent, and really give you a roadmap of the things and the issues and concerns we see as it relates to your pharmacy and what we see on a daily basis here with our pharmacy clients as well. So we do offer that service, and you can go to our website to check that out. And we also, if you have any questions or anything, you can always go to Ask Sykes at sykes-cpa.com, or reach out to us with these numbers or emails here, and happy to help you out any way we can.
And we'll push the questions that are appropriate off to Jesse to answer as well. Also, just so that you're aware, on that RX assessment, you will come away with a complete understanding from a different third-party view of your independent retail pharmacy. All we do is work with hundreds of pharmacies all over the country on the accounting, tax mitigation, and tax compliance side. We've been doing this for 40 some odd years. So we're some 50 people, and this is all we do day in and day out. A couple other questions, we'll let folks go. Do you have to submit 340B pricing to third parties as your UNC price?
So as your UNC price, okay, so that if that is not your usual and customary price, you're not charging it to cash paying customers, then the answer would be no. Your usual and customary price is that which you're charging cash paying customers. Now, a trickier question comes if you have an arrangement, because I've seen this happen, where you have an arrangement with the covered entity where for their patients, you are going to offer a 340B specific price for those cash patients that are underinsured. And that's a little bit of a trickier issue, and sometimes varies depending on the state and depending on the plan. So if you're in that boat, I'd advise you reach out to healthcare counsel. It's a question we've dealt with in the past, but it's a little bit trickier.
This says, is the pharmacy type editable, meaning we are licensed retail, but we are URAC accredited as a specialty pharmacy?
Yes. So when you input the claim to bill, depending on that nature of how the claim is being processed, you generally can change the pharmacy service type. So you could, for example, be a retail pharmacy and have a long-term care line of business, have a home infusion line of business, have a retail line of business, and so long as you are duly contracted with the PBM to do all those things, you can change it, provided that the service that you're indicating is consistent with the service that you're providing.
All right, that wraps us up. We're at 2 p.m. Eastern. Jesse, we appreciate you being so much a resource today. And again, all the contact information of those on this call are sitting here in front of you. And this video will be pushed out to all those that are registered. And again, we hope everybody has a great day. Thank you very much for attending.
Appreciate
it. Thank you.
Bye-bye.
Thank you. Bye-bye.